Am I clearly audible, Digvijay? Anjali? Hope I'm clearly audible and visible here.
Yes,
Great. So welcome to conference 2.2 attendees. This is our third and final session. I would request all the attendees to kindly switch on the webcam, especially those who haven't done today yet. And yeah, do not forget to fill the certificate issue form that will be circulated at the end of the conference in the chat box. Positive. Okay? Do please switch on all your webcams. Respect to webcams. Good evening, everyone. So, welcome back to Conference 2.2 on emerging trends in commercial laws for startups. We hope you had a restful evening and are ready for another day of insightful discussions and valuable.
absolutely, Shravan. We have had the incredible journey exploring the evolving landscape of commercial laws for startups over the past 2 days. Today, we aim to conclude this conference on a high note by delving deeper into the key trends and challenges that startups face in the legal arena.
Before we proceed, we would obviously like to express our sincere gratitude to all the guest speakers and panelists who have generously shared their knowledge and expertise throughout this conference. Their contributions have truly been an invaluable resource in providing us a comprehensive understanding of the subject matter.
Now, without further delay, let's introduce our esteemed speakers for today's session. Introducing our first speaker of the day, Mr. Elijah Putlin. He is an independent arbitrator and counsel at Putlin Dispute Management with extensive experience in various arbitration institutions, including DIFC LCIA, TRAC, TIAC, RAC, ICAC Kyrgyzstan, and ICAC Uzbekistan. He applies his expertise in civil, common, and international law to preside over cases as a sole arbitrator, presiding arbitrator, and co arbitrator. Furthermore, Mr. Putlin has successfully represented and advised clients in a wide range of disputes before prestigious tribunals such as FCAI, SCC, LCIA, ICC, ICDR, and ICAC Russia, as well as domestic and international courts, international trade tribunals, and sporting bodies. His industry knowledge encompasses diverse sectors, including oil and gas, banking and finance, construction, and agriculture. In addition to his roles as an arbitrator and counsel, Mr. Putlin shares his expertise by lecturing on international commercial and investment arbitration at the Tashkent State University of Law. He is a respected member of the SEC Arbitrators Council, the Supervisory Board of the ICAC Kyrgyzstan, and the TIAC Court of Arbitration.
Next, we have Ms. Ijeoma Onoku, an accomplished legal practitioner and arbitrator with specialization in international dispute resolution. Based in London, she is a solicitor of England and Wales, recognized for her profound expertise in online dispute resolution. With over 12 years of post-qualification experience, Ms. Ijeoma has established herself as a prominent figure in the field, actively engaging in global discussions on the merits of technology in law. Her dedication to ODR is evident through her extensive involvement in various initiatives. As a visiting lecturer in law at California State University, Sacramento since 2011, she imparts her knowledge on arbitration and ODR to aspiring legal professionals. Additionally, she also, as a founding member of the Inclusive Global Legal Innovation on online dispute resolution, she actively contributes to advancing the accessibility and effectiveness of dispute resolution globally. Ms. Ijioma's contributions extend beyond academia. She has made significant strides in the realm of publications and presentations. Numerous articles featured in reputable journals and impactful presentations delivered at esteemed conferences. Her insights and expertise have been sought after on an international level, resulting in a role as a delegate for the United Nations Commission on International Trade Law Working Group on ODR. With her unwavering passion for ODR and her commitment to improving access to justice in a digital world, Ms. Ijeoma Ononoku continues to shape the future of dispute resolution, bridging the gap between technology and the legal profession.
Next up, we have Mr. Alex Matogu. With 10 years of practical experience, he is a highly respected legal professional who is a founder and partner at Signum Advocates, a leading law firm in East Africa. His expertise lies in corporate and finance, corporate rescue and cross-border insolvency, real estate and intellectual property. Mr. Alex has provided valuable advice to startups and MSMEs in Uganda, guiding them through registration and compliance processes. As a member of various legal societies such as Uganda Law Society, East Africa Law Society, International Bar Association, and INSOL International, Mr. Alex is dedicated to inspiring excellence with compassion and integrity.
Introducing our next speaker for today, Mr. Vatsal Pari. He is a skilled litigation lawyer with experience in various legal areas, including commercial, corporate, tax, revenue, and civil litigation. He holds a LLM in Constitutional and Administrative Law from Nirma University, India, and a master's in Commercial and Corporate Law from the Queen's Mary University in London. Currently working as a paralegal at the Financial Conduct Authority in London, Mr. Pari brings a unique perspective and expertise to this conference.
Our next speaker is Mr. Simon Peter. He is an advocate and member of the Uganda Law Society and the East African Law Society. He currently serves as a legal manager in charge of litigation at Finance Trust Bank in Uganda. With his extensive experience advising both local and international startups, particularly in cyber marketing and financial services. Mr. Simon specializes in areas such as employment relations, dispute resolution, arbitration, and contractual obligations.
Our final speaker of the day is Professor Robina Nanunja, who is an accomplished international development expert, environmentalist, and honorary professor recognized by the Academic Union of the University of Oxford. With a master's degree in environmental and international development, she brings a wealth of experience in environmentalism, entrepreneurship, international development, business and political leadership, and corporate governance. As the president and chairperson of Pilot International, a private sector social enterprise promoting global sustainability and investments, Professor Nanyunja has worked extensively to facilitate financing and foster cross-border trade across Pacific.
Moving on, we would like to request all of the guests and attendees to kindly switch on your respective webcams during the conference. We'd also like to inform that the HR team is conducting polls in the chat box throughout this session. We encourage active participation from all attendees. Once again, we thank you for joining us today. Let's begin the conversation. Let's welcome the first speaker of the day, Ms. Ijeoma. She is unfortunately not with us today. However, she has sent us a video of a speech. Let me play it for you.
Meanwhile, I would like to request all the attendees to kindly switch on the respective webcams throughout the conference for improved interaction and engagement.
Welcome today to my presentation. My name is Ijeoma Onunubu. I'm a solicitor of England and Wales with expertise in international dispute resolution. My
Your
topic
screen is not visible, Anjali.
is
So just
the impact
improvise
of
it.
My screen is not visible.
It's facing the mirror effect. If you just reshare it once.
Hello everyone.
Now it's visible.
Hello everyone and welcome today to my presentation. My name is Ijeoma Onunubu. I'm a solicitor of England and Wales with expertise in international dispute resolution. My topic for today is the impact of emerging trends of artificial intelligence, legal technology, and blockchain in commercial laws for startups. What is artificial intelligence? Artificial intelligence is the use of a second or third party to obtain some form of intelligence other than the human being. Therefore, any platform or entity used other than the human being will be referred to as a second or third party. In this case, artificial intelligence is the use of an extra party other than the human being to gain access to intelligence. Fei Lee, a professor of computer science at Stanford University, stated, as this technologies, I see how
Anjali, if you can just reshare your screen and begin again.
industrial
The
revolution
screen is actually white, completely white.
time.
If you just begin again.
And then we'll with expert
Is it okay now?
No, it's still white. Is it visible? Big vision?
in international dispute resolution. My topic for today is the impact of emerging trends of artificial intelligence, legal technology, and blockchain in commercial laws for startups.
Just try sharing your screen again.
Technologies.
I think it's a technical defect, very normal. Now it's clearly visible.
Hello everyone and welcome today to my presentation. My name is Ijeoma Onunubu. I'm a solicitor of England and Wales with expertise in international dispute resolution. My topic for today is the impact of emerging trends of artificial intelligence, legal technology, and blockchain in commercial laws for startups. What is artificial intelligence? Artificial intelligence is the use of a second or third party to obtain some form of intelligence other than the human being. Therefore, any platform or entity used other than the human being will be referred to as the second or third party. In this case, artificial intelligence is the use of an extra party other than the human being to gain access to intelligence. Fei Li, a professor of computer science at Stanford University, stated, "As a technologist, I see how artificial intelligence and the fourth industrial revolution will impact every aspect of people's lives. Artificial intelligence impacting on our lives, both from online shopping to online trading to online banking, as well as online dispute resolution. In this case, how does it impact commercial laws with regards to startups? I'm discussing a few of these points today. With reference to what Professor Fei, a professor of computer science at Stanford University, stated, the use of AI is here to stay, and I agree with that. The other question is, what is artificial intelligence? Artificial intelligence is a combination of data, algorithms, and computer power. It's considered an essential tool to serve humankind. One of the biggest drivers of the Industrial Revolution. It's clear that artificial intelligence is one of the big drivers of the fourth Industrial Revolution, which is technological revolution. According to the United Nations, there is importance and the need for access to justice. The UN is working on their Sustainable Development Goal, SDG 16, to be achieved through artificial intelligent robot judges. During the pandemic, China was notably ahead of the game in the sense that there are lots of artificial robots that actually helped with the resolution of disputes. We all remember 2020 when there was a global lockdown. There was no movement anywhere at all in the world. China was able to resolve some of its disputes through robotic judges, the use of artificial intelligence, and ensuring that there was the dealings of all disputes that were out there, both in arbitration as well as in mediation. All these cases received equal measure of work because they had robotic judges, they had the use of virtual courtrooms to resolve disputes amicably to the satisfaction of the client. China, as I said, China is set to launch China has successfully launched an artificial intelligence arbitrator in 2020, which was during the pandemic, and it has this virtual courtroom. China, as I said earlier, is ahead of the rank globally with regards to its use of artificial intelligence because of the population, because of its need to ensure that they're able to cater to its people. Therefore, China has really launched its goals towards ensuring that people gain some access to justice. It's not where it ought to be globally, but China is making some good inroads and taking some substantial advantages for its own good. Artificial intelligence is predicted to have a huge impact for startups in three definite areas. What are those areas that the AI will have an impact on, given the need for commercial laws to be addressed for startups? The first is policy, regulation, and legislation. The second is legal operations, and the third is the future of the legal profession. I'll first of all discuss the policy, regulation, and legislation. The world of artificial intelligence is constantly evolving. and so is the legislation and the regulatory environment in commercial laws. Artificial intelligence is driven by high quality data. Yeah, it's driven by high quality data. Some of the questions out there by people will be high confidentiality protected. It's protected because there is a huge talk right now globally for the protection of individual data through confidentiality reasons. Globally, governments are implementing rules and regulations to help safeguard the use of data. Notably, the European Union General Data Protection Regulation, the GDPR, which is seen as one of the biggest data protection laws out there in the world, is streamlined to protect people's data. Original data protection law, which is the California Consumer Privacy Act, the CCPA, is the original data protection law, which seeks to protect data with regard to California. However, everyone, every jurisdiction is seeking to ensure that they're able to give their consumers, the client, some safeguard, some protection out there because people want to ensure that their data is protected as opposed to having the data all over the place. The other aspect for commercial laws in which AI plays a very big part, which will be helpful for startups, is the application of artificial intelligence in commercial law, making automation simple and repetitive text thing of the past, such as e-discovery or legal bill review, easier to manage. In today's world, everyone is seeking simplicity, cost effectiveness, as well as timely delivery of the matter. With regard to the other point with regards to legal operations is an improved productivity with regards to the use of AI, while driving significant time and resource savings for startups. Therefore, for legal operations, the use of AI ensures that it improves productivity while driving significant time and resource savings for startups, which is really important and commendable. The other aspect of AI, which is helpful for startups and commercial law issues, will be the future of the legal profession. What is the future of the legal profession with regards to AI as it applies to startups? Artificial intelligence has made various aspects of legal work easier and simple. They include legal research, contract review, predict litigation outcomes, and e-discovery. The other aspect is legal technology. Legal technology is advancing at a very remarkable pace. The pace is quite commendable and it's quite interesting because it changes virtually every minute. It's just a rapid change. What is legal technology? Legal technology is the use of technology and its software to provide legal services and support the legal industry. What does legal technology ensure? It ensures the prompt accessibility to justice. It helps assist with the resolution of small claims as opposed to bigger claims. Legal technology also helps with big claims, but it's more accessible for small claims. And the promptness of artificial intelligence ensures that legal technology is enhanced properly with small claims as opposed to the bigger claim. Legal technology also ensures cost efficiency, as I said earlier. It ensures cost efficiency. In 2026, beg your pardon. In 2016, the General Assembly of the United Nations approved the UNCITRAL, which is the United Nations Commission on International Trade Law. They approved the technical notes on ODR, which is the Online Dispute Resolution. They approved a draft technical note which gives consumers and businesses the leeway to have their disputes resolved using the online dispute resolution. I have to add, this is actually a non-binding provision for businesses, but it's a good step in the right direction. It just shows where the world is moving to. Online dispute resolution is the way the world is going, heading towards. Is it called the new evolving aspect of dispute resolution? The American Association, the American Arbitration Association has reportedly used ODR in the resolution of complex cases. That tells you how far ODR has come, given its emergence some 20 years ago, or 20, 30 years ago. But with the pandemic, there's been a heightened need for countries, for jurisdiction, to ensure they're able to use the ODR as a way of resolving disputes, because the world is moving fast, and with the pandemic, we all realize you mustn't travel to jurisdiction to have your disputes resolved. ODR is here to ensure that legal technology has made it so easy, and with artificial intelligence, it's a lot easier to resolve your disputes. The next aspect I'll discuss is blockchain. Blockchain is an open distributed ledger that can record transactions between two parties efficiently and in a verifiable and permanent way. As I stated earlier on, with legal technology, it ensures efficiency and protects and has the tendency to protect data through confidentiality. However, some of the information has to be verifiable. Blockchain ensures this, which is really important and worth noting. The other merit of blockchain is that it is centralized means of transacting work, which gets recorded across millions of computers and hardware in multiple jurisdictions. It also comes down to efficiency, proper management, and it makes things a lot easier and faster. The commercial legal field is developing a consortium to standardize blockchain technology. Smart contract designed to assist startups in commercial laws is really important and really commendable, because it helps the client as well as the people realize the importance of accepting and exploring artificial intelligence. The smart contract designed to assist startups in commercial laws include blockchain version of traditional contracts, self-executing, self-written in code, programmed to execute actions upon completion of certain criteria. Smart contracts will ensure that there's simplicity in self-executing contracts, and a better version of traditional contracts, terms written in code are easily understandable to everybody, and are programmed to execute actions upon completion of certain criteria, which makes it easier and faster. To conclude, artificial intelligence is here to stay, and it's important for commercial law in startups. Artificial intelligence, legal technology, and blockchain will ensure cost effectiveness, timely manner, and simplified version of work done. It's important that startups are encouraged to embrace artificial intelligence. As I said, the topic was the impact of emerging trends of artificial intelligence, legal technology, and blockchain in commercial law for startups. Startups are there to ensure that businesses continue, and artificial intelligence is to help push up as well as help encourage them in the work they do, because artificial intelligence is going to make life a lot easier, simpler, faster, and worthwhile. For this, the impact of emerging trends of artificial intelligence, legal technology, and blockchain in commercial law for startups are here to stay and will be felt positively across jurisdictions now and in a long time to come. Thank you once again. Thank you.
We would like to thank Ms. Ijeoma Onoku for the valuable insights she has shared with us today. Again, Ijeoma went through a diverse range of fields ranging from artificial intelligence to blockchain technology, multiple others, and the role in commercial laws for startups. This is actually very diverse and quite interesting too. Some of the points she mentioned, actually, even I have to learn it for the first time. I really appreciate your contribution to Zoom. I would like to request Anjali if you could just share Zoom's email ID in the chat box. If any of the attendees have any queries, you can just reach out to Gioma via her mail that Anjali will be sharing in the chat box right now. Further, moving on, I would like to invite our next speaker, Alex Matawi in Uganda, to come and speak. Welcome, Alex.
Thank you very much. Kindly confirm you can hear me.
Yeah, we can hear and watch you clearly.
Okay, so I wanted to use a PowerPoint here. If you can just allow me a minute to be able to share.
Sure. Yeah, it's clearly visible, Alex.
Okay, so I'll just look at the presentation myself here. I know that I think it can't be seen from your end. Kindly confirm you can hear me once again so I can get started.
Yeah, we can hear you clearly.
Okay, great. So I'm presenting on the subject, simplified reorganization regime for SMEs. We all know that access to credit is one of the biggest issues that startups are going to be facing or are facing. And I've come up with research on the need for a simplified reorganization structure for these startups, most of which are micro, small, and medium-sized enterprises. In this presentation, I'll try to explain what business reorganization refers to. I'll also talk about what SMEs are. And of course, as you realize, we don't have a single definition of SMEs, but I'll try to highlight the key features of SMEs and where most of the businesses start up, what they're categorized as or how they're described. And then I'll explain, give a few reasons why I think there's need for a simplified reorganization structure. I'll also talk about the common features of simplified reorganization. What does it mean for a reorganization procedure to be simplified? And then I'll make some recommendations. As you realize, well, attempts have been made, there's need for more work to be done. So that's really going to be the subject of my discussion this afternoon. So to start with, in a contemporary free market economy, credit is indispensable. I came across statistics by the World Bank that show that by 2020, global debt had reached $226 trillion. And that's about 257% of the global GDP. So you can imagine how much of debt out there is. And of course, there's a presupposition that you know, we need debt, and once we acquire debt, we are able as businesses to use it to grow our businesses. But in reality, once we borrow, then there's also a reality or high possibility that we'll default. And that's why the law of insolvency and business reorganization becomes necessary. Insolvency law, therefore, exists to protect creditors' rights and possibly, where possible, rehabilitate businesses. So basically, it's not true, as many have thought, that whenever you hear the word insolvency, it means the business is going to close. The intention of insolvency law is to make sure that creditors are paid, but also, where possible, businesses are saved. Now, as you will see, the level of contribution of SMEs to the national and global economy, it is extremely important that we don't only get creditors paid, but we also intentionally create laws and policies that enable indebted businesses to survive. Because as we've noticed, default is going to be inevitable in many situations, and so the laws can do a great deal in solving this problem by enabling reorganization for businesses to continue. Now, insolvency laws, on the other hand, have also presumed largely that there's a sufficient estate. What that means is that when businesses are indebted, once they go through the insolvency proceedings, there's enough money not only to pay off creditors, but also to meet the costs of the insolvency proceedings. Unfortunately for SMEs, this is not the case. And that is the reason why majority of them have ended up being wound up or liquidated. Every time they get into debt, majority are not able to survive. And the point I'm making in this research is to show that if our business reorganization system or procedures was more simplified, maybe it could be more attractive to SMEs, where many of the startups fall. Now, what is business reorganization? Reorganization refers to any method by which the capital structure of a company is modified and includes any form of restructuring, whether contractual or under the law. Now, as you will see, as I'll explain through this presentation, not all reorganization methods are provided for in the law. Not all reorganization procedures include a court of law. They may or may not involve a court of law, but they are simply about, or it's simply about the process through which entities that are indebted or distressed are able to reorganize their capital structure, engage their creditors, and in the process be able to survive. Or not survive, or even close, but essentially it's about the reorganization of a company's capital structure. Now, the goal of all this is to address the debts of all creditors and to ensure continuation of the distressed businesses, as I've mentioned before. Now, remember, there are other insolvency procedures. These include receivership, they include liquidation, they include foreclosure. But these other methods, unlike reorganizations, are targeting creditors who are secured. So, for example, for receivership, a secured creditor appoints a receiver to run the business. But the goal in there is to run the business for the sake of the creditor recovering their money. Reorganization, on the other hand, is looking at catering for all creditors, including the unsecured creditors. That's why it's a very critical and relevant procedure when it comes to the survival of businesses. So, what are the types of reorganization? Reorganization can be a court process, it can be court supervised, it can be out of court, or it can be a hybrid. Now, what does that mean? Court supervised refers to a situation where proceedings are filed in court and court has oversight over the process. It is normally binding on all parties. On the other hand, on all creditors. On the other hand, the out of court process involves the indebted company calling on its creditors and saying, can we have an arrangement? Can we have a discussion that allows me to renegotiate the payment terms or even the payment period so that I can pay in an adjusted and agreed manner? The challenge with out-of-court reorganization is that it does not bind the creditors that are not party to the process. So if you had, for example, 10 creditors and called 5 of them and entered an arrangement with them, the challenge with that is that not everyone is going to be bound. The ones that are not party to that out-of-court discussion will not be bound. Now, the alternative there is the hybrid method, which is a new and innovative way of allowing companies to reorganize or businesses to reorganize, but still have the endorsement of court or an administrative third party. That way, the outcome is binding on all parties, even if the discussion initially did not involve all creditors. That's what the hybrid does. It's a combination of the benefits of the out-of-court procedure, yet benefiting from the endorsement of court, which ends up binding on all creditors. The forms and procedure of reorganization differ across jurisdictions. Some jurisdictions will, for example, the US will have one recognized procedure for reorganization. The UK has 3 of them. Italy and Germany have a plethora of them, so many of them. So that there's a difference amongst jurisdictions. And I'll mention during this presentation what the risk of that would be. But generally speaking, research shows, according to Professor Philip Wood, countries where reorganization is the most common insolvency proceeding and not liquidation and not receivership, countries like that record higher business recovery rates. And that's why it's important that reorganization is pinpointed and improved as a method for dealing with company debt. Now, going into the definition of SMEs, because the topic is about simplified reorganization for SMEs. As I mentioned earlier, there's no universal or universally recognized definition of the term SME. And you can understand this because of the divergency in the economies, divergency across, the fact that many SMEs are not even registered. I came across a statistic in about India that shows that for every one registered SME in India, there are 17 that are not registered. Can you imagine that? For every one registered SME, 17 are not. About India. And that's just India. There are many other countries, right, where we know that majority of SMEs are not incorporated. Of course, there are several reasons, as I'll discuss in this presentation. But the point I'm making is that it becomes very difficult then to have a single division of SMEs when many of them are not even recognized. They are operating, but you cannot even come across their characteristics with specificity because they are not recognized by the authorities. But that said, researchers have come up with common features, which I'll just highlight for us to think about every time we think the word SME. Number one, they have a simplified organizational structure. Number two is they have a simple financial structure. Number three is most of them are not incorporated, as I've mentioned. Also, most of them are owner managed. What that means is that there's no separation between the shareholder and the directors, as it is with a common definition of a company. And we'll see what that means in terms of debt. There are many other characteristics, including the fact that most of their debts are guaranteed by the owners. But in the interest of time, I'll move on to the justification as to why it's important to have a simplified reorganization regime. Number one, SMEs, and I would like to share some statistics on this. SMEs have a huge contribution to the global significant contribution to the national and global economy or global GDP. Some of the statistics I came up with are from the World Bank, and they show that SMEs contribute 90% of business. They constitute 90% of businesses across the world. SMEs also contribute more than 50% of employment across the world. More than 50%. SMEs in emerging markets contribute 40% of GDP and create 7 out of 10 jobs. Now imagine that. That's 70% of the job market. Now, if you're talking about unemployment, especially in the emerging markets, imagine if you did not support SMEs and they're not able to survive, the effect that can have on employment in our markets, right? Now, you may be thinking, of course, this only affects the emerging markets. How about the advanced economies? Research also shows that in the advanced economies, micro, small, and medium-sized enterprises account for 95% of the total number of businesses. 95%. Now, for emerging markets, it is 90%. For the advanced markets, it is 95% of the total number of businesses. 60% of total employment and 50% of value addition in the private sector. Now, that's how important SMEs are, or these startups that we are talking about. And that's why, for me, it is important not to leave them out, not to create a business reorganization structure that presupposes that all businesses are big, because they are not, right? There's a very big percentage that is not as big as we think. The other reason I would suggest a simplified reorganization structure is the nature of incorporation and management. As I've mentioned, in India, every one business that is formal, 17 are informal. Imagine that. Even the registered ones, majority are owner managed. Now, what that means is that if owners are the guarantors of company debt, it means that every time a business is in debt, the individuals are going to be affected directly. Now, the question is, how likely are they to participate in a process where they know they are going to end up arrested for the business debts? You see what I mean? For big businesses, on the other hand, there's a separation where you know that if debt is company debt, it does not come to me as an individual. Now, for that reason, many businesses will not come out to say we are indebted or we need help, because there's an emotional attachment. There's a connection between the owner, a direct connection between the owner and the business itself. The other challenge is access to financing. As I've already mentioned, most of these businesses are informal, meaning whenever they go to lenders, they're not going to be attractive. For that reason, they will not be able to get debt, whether at the start, during, or even at the time of indebtedness. Actually, when they're indebted, they're less attractive. And for that reason, they will not be easily get financing, which makes the reorganization procedure quite difficult. The other two reasons, and in the interest of time that I will not be able to explain before I move into the recommendations, are the fact that there's a complexity. Small and medium-sized enterprises view the insolvency and reorganization procedure as quite complex because they require a lot of documents, because the process is lengthy, because there's a number of issues in there that need to separate management from the administrators from the people that run the businesses during the reorganization procedure. For small and medium-sized enterprises, that's quite difficult and not practical for them. So for that reason, you will find that the process is not attractive. There's inhibitive cost of reorganization. According to the UNCITRAL legislative guide on insolvency law, most SMEs find the cost of reorganization inordinately expensive. So we need to go back to say, as lawmakers, as policymakers, are we making the reorganization procedure attractive for SMEs, or even sensitive to the fact that they have unique features that may not enable them to follow the procedure as it would be for the bigger entities? Now, I'll just touch briefly on the countries that have managed to create a simplified reorganization procedure. They include Australia, Colombia, Chile, Singapore, US, Myanmar, Japan, Korea, South Korea. There are a number of them. But basically, this is what we see for many of these entities that have managed to come up with a simplified procedure. Number one, they have strict timelines for the commencement of the insolvency proceedings and approval of a reorganization plan. So what they do is to try to cut the process as short as possible to enable SMEs to go through it faster because they don't have the funds, as I've already mentioned. There's also fewer formalities for the commencement and approval of the reorganization plan. So they don't treat small and medium-sized enterprises the same as their bigger entities. What they do is they create a shorter process, fewer formalities, and lesser demands for these entities to be able to go through the reorganization procedure. There's also an assumption, and I'll just end with this on that particular point, of the data in possession model. Data in possession means that there is no need to appoint an independent third party, insolvency practitioner or administrator during the reorganization procedure. They allow the managers or the owners of the business to continue in possession as the business is running. And then they'll appoint a supervisor to oversee the process, but without taking them out of the business. Because appointing a third party is an additional cost. So what these countries have done is to allow a data in possession approach, where the data remains in possession and running the business while they're being supervised to ensure that there's no misbehavior or any misconduct that happens during that process. Please allow me, in the 1, 2, 3 minutes that I'm left with, to just touch a little bit on what the recommendations are, in my view, on how all these countries can help to better their reorganization procedure. Number one, we need a harmonized best practice standard for SME insolvency. Why do I mention that? The countries that I've given are all coming up with their own reorganization procedures, which then means that if I'm a startup, I always have to be looking out for the country that has the most favorable business reorganization procedure. What that really means is that there's going to be some sort of forum shopping, which SMEs with their kind of income and revenues are not able to do. But if we set guidelines that then become the benchmark for each country to customize its own laws, I don't need to move as an SME from the UK to India or from India to Uganda or to any other country. The idea is to try to create consistency, but also make it very affordable and encourage SMEs and startups to start up anywhere. They don't have to be thinking which country has more favorable laws. So I think that's, for me, is very important as number one. Number two is to create enhanced protection for creditors that support distressed SMEs. If any of you has studied or read about sovereign debt, where countries borrow, in terms where countries are doing what we call debt restructure, we have the preferential creditor status, but we don't see it in private insolvency proceedings. Preferential creditor status is allowed for any lender who accepts to lend to an indebted country, right, in a time of distress. So they have taken a higher risk. That's why you realize that the IMF, World Bank, and these multilateral development banks are given special status because they're able to lend. Now, that allows entities that are in distress, but if saved, could continue and move on as going concerns. I suggest that that is also thought about in relation to businesses so that entities can be encouraged to lend to SMEs that are in distress. The other thing, of course, that can be done in relation to enhancing creditor status is for countries to consider, governments to consider a haircut. We call it a haircut in debt management, where creditors allow to have a reduction on how much is due to them so that everyone can share something. Now, what we find in many countries is that taxes are always have to be paid first. If you're going to pay taxes first, it means that the entity will be left with very limited amounts of money to be able to pay the other creditors. And that will be discouraging for any creditor to come to the table in a reorganization procedure. No wonder the secured creditors normally run out to make sure that they are paid first, because they know government is not going to consider a reduction on its own dues. So why should I consider a reduction on mine? You see that? So that really, I think, is something to also look into. The other aspect is better coordination between the systems of corporate and individual insolvency. Or what, countries have even termed it as bankruptcy. So they consider the personal insolvency as bankruptcy and then the company insolvency as insolvency. But I think there's need for a coordination of the two. What do I mean? SMEs, by virtue of their structure, have no separation between the individual and the business. Now, what that means is, for me, what I'm suggesting is to say, and what research has shown, is that if you want to make a better reorganization structure that is attractive to SMEs, guarantee them that there'll be a closure to the personal debt, a separation of the personal debt from the company debt, right? So that way, SME owners are encouraged. It will be motivating for them to come into a process where they know there's going to be a separation between them as individuals and the company debt, because the two are different, right? Guaranteeing a company debt does not make it your personal debt. Being unfortunate enough does not mean you're dishonest. So it's important to separate dishonesty from being unfortunate as a business. That all things can be planned and, thinking that things will go well, and they don't. Remember the COVID scenario that we had. People were genuine, honest business.
Sorry to interrupt, Mr. Alex.
Yes, please.
If you could just wrap it up in the next 2 minutes, we are planning out.
Okay, perfect. I'm concluding. So the last 2 points are really make it easier. The law can make it easier for these businesses to access free restructuring advice, especially using technology. The previous presenter has talked about AI. Instead of creating very cumbersome documents, use technology to make these documents accessible, to make the reorganization procedure easier to commence, documentation not needing to be paid for, so that it's easy. The last point is relevant reforms besides reorganization. We all know that every time the word insolvency is mentioned, everyone tries to run away. No one wants it. The thing I'm encouraging governments to do and policymakers is to always advocate for the removal of stigma around the word insolvency. To be indebted is not a crime. To be indebted can be a result of genuine business dealings that face unfortunate times. Thank you very much. I'll end there in the interest of time. Thank you.
Thank you, Mr. Alex, for sharing expertise with us. Your speech was both informative and thought-provoking. We appreciate the valuable insights you've provided to us. Please share your email address in the chat box. If anyone in the audience would like to connect with Mr. Alex or has any questions, please feel free to reach out to him through the email address. Now, I would like to request our next speaker, Mr. Vatsal, to commence his speech.
Okay, I am sharing my slides. Is my slide visible?
Yes, it's your screen is visible. If you could just go to your presentation, we can see your slides.
Uh, is my slide visible or is it not visible? Because I am not able to see. That's why.
No, it is not visible.
It is visible.
We can
Sorry.
see your screen. If you can just go to the presentation.
Your slides are not visible. WhatsApp. Just try to reshare your screen once you are placing the mirror effect.
Okay, let me just reshare. Yeah.
Yeah, perfect.
Now is it visible?
Yes,
Now
we
is it
can see.
visible?
Yes, we can see your screen.
Okay.
Yes, sir. Now only it is visible, sir. Thank you.
Okay. Great. Thank you. It is my extreme honor and privilege to present myself on the e-platform of SK Associates and Group before the diverse individuals who are very well respected in their field and international gatherings of entrepreneurs, PhD scholars, and students across the university. I also express my sincere gratitude to Shravan Kumar and Anjali Singh by thanking them for providing me with this invaluable opportunity. Before I start my speech, I just want to start with a quote said by Steve Jobs, the ex-CEO of the Apple, who says that just a second, I successfully, just a second. I'm not able to change my slide. I don't know. Can you just check? I'm not able to change my slide basically.
Why don't you click on F5 on your laptop keyboard? The slideshow will begin automatically.
Sorry?
F5.
If you can just refresh your screen once, the screen might have been hanged. Or you can just tell your speech without the presentation.
Don't have.
Please unmute yourself, Mr. Parekh.
Is my slide visible now?
Yes, it is visible.
But I'm not able to change the slide. That is the problem.
Why don't you just continue, like with your normal speech without a slide? Even that, or you could even refer to a slide at
But
the back.
I don't know, but if I'm pressing F5, then I'm getting exit from this.
If you can just go to the slideshow section on the top of your MS smartphone.
Go to right side, click on the slides, it will run, sir. I think so. So next slide, there is on right side, you could have slides, just click second slide, it will open, sir. Instead of scrolling
There
it.
is no option that works basically here. I don't know, but It's just the slide is coming, but after that there is no option that works.
You
You can
just
just
take your
click on the
cursor.
second slide, which you can view in the.
Yeah, I clicked, but it is not coming.
Okay, and then that might be a network issue or the issue with the laptop.
No,
No issue.
network is like full basically. It's
Restart
full.
it, sir. At least one time restart it and it could find it. I think so. Do it, restart it again. Close and open it, it will run, I think so.
Now is it working?
We can see the slides.
Go to next.
Okay, okay.
Yes.
Now it is started. Now it is started.
Yes,
Sorry,
it's
sorry.
fine, fine.
Yeah, sorry. So it is my extreme honor and privilege to present myself before the SK Associates and Group on their e-platform before the entrepreneurs, international distinguished speakers who are well recognized in their field, and before the international gatherings of entrepreneurs, PhD scholars, and various graduates from universities across India. I express my sincere gratitude to Shravan Kumar and Anjali Singh by thanking them for providing me with this invaluable opportunity. I want to start my speech with a quote said by late Steve Jobs, who once said that I am convinced that half of what separates the successful entrepreneur from the non successful one is the pure perseverance. So, to all the budding entrepreneurs, your startup journey can be full of legal challenges and regulatory obstacles, but your patience, perseverance, and burning desire to succeed hopefully will stand to the test of the time. Now, let us move to the next slide basically. Yes, the list of the emerging commercial trend. India is currently witnessing a wave of startup. The number of startup is increasingly in the country. According to the Department for Promotion of Industry and International Trade, at present, India has a 92,683 recognized startup as on 20th February 2023. The increased number of startups not only help in the economic growth of the country, but also act as a source of the foreign direct investment and helps in creating more employment opportunities. As we all know that the startup in India face several challenges and problems that can make it difficult for them to succeed. From limited access to capital to complex regulations, startup founders in India must navigate various obstacles to establish and grow themselves to succeed in this competitive environment. This is because if we introspect recent emerging trends in commercial laws, it has both positive and negative impact on the startups. Startups have obligation to operate in compliance with the laws. Failure to respect the laws can give startups serious problems such as a fines, punishment, revocation of license, litigation expense, etc. And that too can adversely affect the limited capital of startup. Today, I am going to speak on some of the untouched areas of emerging commercial trends. As we all know that on the day one and day two, we have discussed on the basically cyber law, cyber security, direct taxation, commercial arbitration, funding of the startup. Today, I am going to discuss on some of the untouched emerging commercial trends which can affect startup considering the new Digital Personal Data Protection Bill 2022 and the Consumer Protection Act 2019 Act, which is already there in the place basically. So as we all know that the evolving the new Digital Data Personal Protection Bill 2022. Now the question is arises in all mind that why this proposed bill is important and relevant for startup. So as we all know that when we particularly today in the digitalization world, first of all, when we go for any of buying the product, first of all, we always look for the online purchase. Like for example, purchase from Flipkart, Amazon, Myntra, etc. Right. So what does this e-commerce startup does is that they record your data and store your information. So the moment you visit the website or the app, they automatically record your data and your personal information. So this can definitely affect to your personal data, personal information and data breach basically if they share their information to the third party. Another thing is basically is that the data there is also an consequence of the sensitive data that can be leaked by this e-commerce startup basically. So this the new digital data protection bill has brought into the place to overcome all these challenges and to for the Indian country and to determine how to store it personal and process the personal data of the individual by protecting the right to privacy of an individual as regulated by Article 21 of the Indian Constitution. Now, origin of the bill through Europe General Data Protection Regulation. So, in 2018, Europe GDPR has taken in place the General Data Protection Regulation. After that, inspired of that General Data Protection Regulation, many of the countries have introduced new data protection regulations in their own country. India is also one such country who has also adopted the new Digital Personal Data Protection Bill 2022, which is currently in the pipeline. Now, the third thing is regarding the applicability of the proposed bill. The proposed bill will be basically applicable to for the digital personal data, that is for the data that has been collected online, and another thing is that the offline data subsequently which can be digitalized. Another applicability of the proposed bill is basically is that it can also apply to the extraterritorial jurisdiction. So basically, if the goods and services are exchanged across the world, the foreign entities can also be covered under this data as and when the conditions are satisfied. Now, before we proceed, basically the thing is that we need to understand the key terms. For example, of this digital personal data protection bill, which are important for the startups. The first thing is regarding the personal data. Personal data means the personal data of the individual, that is name, email address, debit card, credit card number, telephone number, etc. So whenever we go and buy any product online, basically we always share our own personal data. The another thing is the data fiduciary, that is the controller. That is the, for example, an e-commerce startup company, right? So when you go and buy any product, e-commerce startup company from an e-commerce startup company, the e-commerce startup company collects your data, processes your payment, and then deliver the goods and services at your place. So this is how they collect your data of being a controller. Another thing is basically the data processor, that is the third party payment processor. So it's a place where how the your data is going to get processed. So for example, if the third party, how it collect the payment on behalf of the e-commerce company, and how they basically processes your data. Now, how the startup will be impacted through new digital personal data protection bill 2022. Now let us discuss the pros and cons of this bill. The first pros is regarding the support in ease of doing business at a global scale. With the proposed digital personal data protection bill 2022, it will invite the global entrepreneurs and the startups globally to come and do their business in India, as it will help in supporting the Indian economy, and as well as it will also help in boosting countries' economic growth. Another thing basically is that if India will implement this digital personal data protection bill 2022, which is most likely to going to get implemented, it will also helps in protecting personal data of individuals and other organizations, companies, etc. As this will definitely help in ease of doing the business in the country. The second thing is basically the increased accountability. The increased accountability is regarding the managing sensitive data. So it is very beneficial for the startup that how they are managing their sensitive data, how they are doing their data protection assessment. So this will help to avoid any data breach or data leak, and as well as it will also safeguard the consumer's personal data. The third one is enhancing cross-border data flows. The another thing basically is that in the earlier DPDI bill, it was basically there was a provision of the data localization, which can significantly increase the cost of the startups, as it might not even allow the startups for certain specified countries to not sell their goods and services. With the enhancing cross-border data flows, it will help the startup to sell their to export their all the goods and services in as specified by the government in the respective countries, and it can definitely help to boost the startups. Another thing is that with this enhancing cross-border data flows, it will help in reducing the cost of the startups basically in compliance. The fourth thing is regarding the non-retention of personal data. As we all know that in this new proposed provision bill, the personal data should not be retained by the startup if it is satisfied for the purpose that has been taken for, or the data which has been collected is not required. So it will help in avoiding data breach and data leaking. So after once the personal data is collected, and if the startup company is not required that data, they can definitely delete that data basically. Now let us discuss the cons of the bill and how the startup will be impacted through this bill. Compliance requirement and increased cost. As we all know that the new DPDI bill discussion is always around the corner in today's days. As soon as this bill comes into effect, all the startup founders, entrepreneurs, any companies or any organization across the country have will their compliance requirement will definitely increase, as they need to appoint some data protection officer basically to deal with all the compliance data, processing personal data, and storage of the personal data. Another thing is basically the privacy policy. With the every companies, as now also we have seen that before the enactment of the DPDI bill, most of the companies and startups always have their own privacy policies basically, and sometimes we need to agree with their privacy policy as well in order to proceed. So with this new the privacy policy is taken into place, and because of that, it can also affect the startups to change their ecosystems according to the need of the laws. Another thing is that in privacy policy, the startup founders has to determine for what reason the data has been collected, how it has been collected, whether it will be shared with the third party, how long the data will remain confidential, and for what reason the data shall be collected. The third thing is the customer expectation and the trust. With this bill, it will be an obligation on the startup founders and the startup companies and also the new startups particularly to build the customer satisfaction and the trust. As we all know that the customer satisfaction and trust is very necessary to boost your business in today's generation. So it will be a big obligation on the startups, particularly to build the rapport among the customers and avoid the personal data, and the data breaches. The fourth thing is the penalty. Now, this is one of the very significant factor in the new DPDI bill. There is a significant amount of penalty that has been imparted, particularly if there is a non-compliance of the laws, then the direct penalty is of 500 crore. Now, it will be very difficult for the new startup, particularly, to comply with this such kind of very heavy penalty, where since they are always having the problem of funding of the capital. So I believe that this DPDI bill, although they have a very good positive impact, but it also a very adverse effect as well, considering the penalties and the compliance requirement and the increased cost. Now the another e-commercial trend that I want to discuss is the contemporary development in e-commerce and how it has impacted startup through new Consumer Protection Act 2019. Now, as we all know that in today's digitalization world, everything is moved digitally. The customer buys everything online first and then might decide to visit to the store if necessary. But most of the time in today's generation, it is seen that for all the startups, as they also work online, the new Consumer Protection Act 2000 plays a very pivotal role in it. Now, how this act has basically impacted the startup basically. Now, the earlier Consumer Protection Act 1986 was not having any provision for the online intermediaries and the e-commerce companies platform. The new Consumer Protection Act 2019 has introduced the provisions for the intermediaries and e-commerce platform basically. Let us discuss with one example. For example, consumer data and studying consumer pattern. Most of the e-commerce platform, as you know that Amazon, Flipkart, Myka, Naitra, etc., always use artificial intelligence to study the consumer pattern. Like for what kind of product that you are looking when you open their website or app, and as a result of this, they continuously provide the same kind of similar suggestions. So this happens because of this this happens basically because of this artificial intelligence used by the startup. The new act has made an obligation that whatever data they receive from the customers, they need it need not to be said, and from what reason the data has been collected needs to be disclosed basically. Another thing is the product liability. In 1986 Consumer Act, we have all heard one very common term, caveat emptor, let the buyer be aware. In the 2019 Consumer Protection Act, now it is there is a paradigm shift, that now it has been on the seller particularly to decide what is their product, that everything whatever they sales or provide goods and services, every product, the liability will be on the seller and not on the buyer. So it will be very difficult for the startups to sell or to decide to sell any products by considering the liability of the buyer and not on the seller. So this is one of the major issues that
Mr.
in
Parekh?
the consumer protection. Yes.
Okay,
Yeah, now it's
no, there were some network issues from your end. Okay, no issues.
yeah. Now we're audible. Please continue.
Okay. Just I'm repeating this mediation, alternate dispute resolution, in case if you have not heard because of the network issue. Now this is a significant provision that has been introduced in the new Consumer Protection Act
By the way, I had to
2019.
request Mr. Parik if you could just wrap it up in 2 minutes. That would be a pleasure.
Sorry.
If you could just wrap it up in 2 minutes, it would be a pleasure.
Yeah. Definitely. Just give me 2 to 3 minutes. I will definitely wrap up. The another thing is basically the compliance with the e-commerce rules 2020 and 2021. Now it's a big obligation on the startups that they have to comply with the e-commerce rules 20 and 2021. Basically for the process of their selling the goods and services. The last two points is regarding the fallback liability clause on the e-commerce entity. So whenever if there is any deficiency in the services by the startups, there is a fallback liability clause which comes on the e-commerce entity. So they are liable to pay for the damages, etc. Now the final thing is regarding the way forward. So basically, since we have analyzed the commercial trend, the basically in my opinion, I still believe that there is a need for legal certainty. Another thing is that there is a need for close examination of certain emerging commercial laws, as we seen that technology has gone hand in hand with the evolving process. But still I believe that there is a close examination of certain emerging commercial laws is required to enable startup to foster and contribute to the economic growth. The last thing is regarding the robust legislative framework is needed for the growth and survival of the startup. I believe that there needs to be standardization, like for example in Texas, for the new startups there is a 3 years tax holidays particularly for the new startup, but the standardization is not in provided in the new DPDI bill, etc., and even in the Consumer Protection Act 2019. Thank you so much.
We would like to suggest. Thank you, Mr. Parik, for a wonderful speech. Your expertise in consumer protection, especially, has provided us with a deeper understanding of the subject matter. Please do share your email address in the chat box so that if any of our attendees have queries, they can connect with you. Next, I would like to request Mr. Simon Peter to commence his speech.
So, good evening, everyone. I hope I'm audible enough. All right. I would like to thank Kumar and your team for this opportunity to speak to everyone at this conference on the issues pertaining to the emerging trends in commercial laws for startups. My discussions this evening will be particularly pertaining to the Ugandan situation, but in relation in particular to the dispute resolution process that startups would find and face within the country, and also the best options that those who are interested in setup within Uganda can opt for in order to have quick and straightforward resolution of disputes within our jurisdiction. In preparation for today's conference, I came across a very interesting quote from two writers who basically described innovators startups as disruptors. And I believe really as disruptors, what startups come into in any country is always to upset the status quo and to set up something unique and different. But of course, being elements that are unique definitely challenges to the legal systems as well as to public perception is always anticipated. Now, Uganda as a country is quite robust. According to recent statistics, 78% of our population is actually below the age of 35. And by standards, these are the people who are using technology. These are the people who are driving change. And these are the people actually setting up these startups. So what normally happens is that because of the age and because of the drive that these individuals have, if you look particularly in the case of Uganda, probably I would say 90% of all startups here are driven by individuals within this age group. Now, in Uganda in particular, for startups that are going to come in, there are very many avenues that you're going to interact with, and registration, compliance, as well as regulatory bodies that will oversee how you're going to set up, how you're going to manage your startup, and also how you're going to resolve disputes that are going to arrive within the operation of your startup. Right from the point of entering the market, you're going to deal with elements of registration and formalization. The previous speakers have spoken about this, especially Alex, who looked at the aspect of SMEs. But if you look at the aspect of Uganda, Uganda gives you a broad range of how you're going to set up. You could be a partnership, you could be a company limited by guarantee, limited public company, private company. The choice really depends on how you're going to set up. And in that setup, you're going to interact with our, what we call the Uganda Registration Services Bureau. In there comes the element of formalizing your registration. Currently, we are having a shift from what initially was the donkey paperwork in the process of registration to now move to a more online-based system to enable a quick process that can have business entities register even remotely and get documentation as quickly as possible. Payments are now being done online such that from the seat of your office, you can actually handle your registration process. But within that also comes aspects of what will pertain to your business, your intellectual property, your copyright, your trademarks, all these aspects that are going to be governed by the body. And being elements that have contentious aspects, definitely disputes do arise in relation to that. Currently, our laws empower the offices, particularly the office of the Registrar of Companies, as well as the Trademarks Office, to handle disputes. One, in regards to particularly trademarks, to examine aspects of challenge, because once you are in the process of setting up your trademark, indeed you're going to have to go through the process of advertising and gazetting your trademark. And in there come challenges to your particular trademark. Now, particularly what's good is that such a dispute is going to be managed at the registrar level in terms of the opposition that someone may have to this trademark. And all these are actually now being exemplified through the rulings that are coming out from these offices in relation to these aspects, because the registrars are now empowered to examine this dispute. What is the reason for the challenge? Is it proper, or is there a reason to actually overrule this challenge and allow that to go on. This, in essence, actually saves the process of what could have been a lengthy dispute as to a back and forth of exchanges. But now you have everything grounded within the same office that is going to handle your licensing. And that gives a very good ground for the dispute settlement. To move on, secondly, of course, when you come in as a startup within Uganda, definitely in the process of your setup, you also have elements pertaining to who are going to be your bankers, who are going to handle the money that your funders or yourselves are going to handle. Because now, as it is, through the process of registration that I've talked about earlier, the banking system also now requires compliance with other regulatory bodies, for example, the Revenue Authority, for example, even our National Social Security Fund. We need to see that indeed you are compliant and you have certification to show that you're in business. So when you're setting up these accounts and also formalizing the processes of transfer of money between countries, one thing that came up this year through the registration process is the full disclosure of who, what we have termed as the beneficial owners. These are the people who actually derive a benefit from this venture. Now you're under the obligation to disclose these individuals, both to the registration bodies as well as to your financial institution. Reason being, you now need to show that this is not just a venture to move money illegally, but is actually derived towards a certain process of business. Of course, this comes with a penalty attached to it for non-compliance. And of course, this is something that we are now advising all business entities in terms of compliance. It is one of those aspects that you need to actually have at your hands and ready to set up. Of course, now when you've set up also here in Uganda and you're employing certain individuals, we had an amendment to our National Social Security Fund, which requires now any entity that employs, regardless of the numbers of employees, social benefits have to be remitted. Initially, Uganda had only a situation where you had to have a minimum of 5 to start the process of providing for this. But now, the new law that came in last year has put it that you have to provide for all your employees, regardless of the numbers. And the absence of having this means that you will not get clearance even to operate and get a tax clearance certificate from the Uganda Revenue Authority. So all the systems are now getting interlinked in that you cannot do without. So what does that mean? When you come into the country now, the key thing that you need to look at is your documentation. What we're advising most of SMCs and startups and all partnerships and whatever business entity that is going to come in is the fact that within your contracts, dispute resolution is actually going to become a very, very big factor. And how you're going to handle that is quite key. Options, of course, do exist because as the process, litigation is always inevitable, but what we always advise is if you can avoid litigation through alternative dispute resolution, that would save you all the time and money in the world. Currently in Uganda, arbitration is provided for both under our laws, and also courts have gone ahead to make sure that the terms that are expressed within your contract pertaining to arbitration or mediation should first be explored. Now, what does that mean? This means that if you include such clauses within your contracts, you're actually saving yourself the burden of going through a full-blown process, which may take, by example, in Uganda here, perhaps a minimum of 3 years before you've even resolved. So currently we have what we call the International Center for Arbitration and Mediation in Kampala, ICAMEC, which handles arbitration within the country. And the beauty about this process is that it is handled on a 50-50 basis, such that when you as a business refer your dispute to this entity, at the end of the day, the cost of the process actually, if you're able to agree, can be split if you're able to reach a consensus without necessarily having to refer. So that will save you actually in the long term. We also have what we call the Center for Arbitration and Dispute Resolution, which is managed under our judicial system. And of course, that is also governed under its rules. We do explore aspects within mediation as the parties indeed may want to explore, perhaps through one mediator or a panel, whichever that the parties always want to determine. So the option for startups within Uganda in terms of dispute resolution indeed give an aspect which can guide in terms of cost benefits, but also time. Because if you look at the arbitration process vis-a-vis the litigation process, you actually save a very huge amount of time.
Excuse me, Mr. Peter, if you just wrap it up in 2 minutes.
Absolutely. I'm at the tail end in about a minute or two.
Sure.
Yes. So this is basically where we do advise our businesses to focus. And in terms of those who would be coming into the market, always consider your dispute resolution clauses as something of paramount interest to save you both the time and the energy that you would employ in the entire process. I'd like to thank you for the time, and I hand it back to you, Kumar.
Thank you, Mr. Peter, for your words and obviously the knowledge that you contributed to this event. Your legal expertise has actually greatly enriched our discussion for today. Please do share your email address in the chat box. Anyone in an audience would like to get in touch with Mr. Peter for any questions you have, please do reach out to him through the email. I will commentary on this. Now, I would like to request Ms. Neha Keshan to share the Google Review link for the conference in the chat box. So attendees, here we have brought you to the 22nd conference hosted by SK Associates in Europe. I would like to request you all to kindly drop a small feedback in our review section so that we might know any recommendations or suggestions you have so that we can improvise the conference according to your new ideas. Okay. Since you are the audience and obviously feedback is what helps a startup grow and boom in the longer time, we would really appreciate your contributions in our Google reviews. Be frank and do criticize some aspects of us which you didn't like, and we would appreciate and want it changed, and to give your valuable recommendations. Each of them can make a huge difference. Thank you. Anjali, you may continue.
Now I'd like to invite Ms. Robina to commence her speech.
Thank you so much, Ms. Anjali, and also the organizers of this conference. I'm very happy to be part of it and going to make a contribution towards it. I hope I'm very audible. Yes, I'm speaking from Uganda, but my perspective
excuse me, Dr.
is...
Nanninja. Your video is not visible. You can just switch on your webcam.
But can you hear me?
Yeah, we can hear you, just that you are not visible.
Yeah, I'm kind of on the road, a bit off.
It's
I hope that...
We're fine with that.
Yeah, I just hope that I will just read.
It would be fine, but we would appreciate seeing the dignitary as
a presentation, my text, and I hope you will be able to follow. Yeah. Yes, so first of all, my speech is about startups, globalization, as well as international law. I would like to say that emerging trends for commercial law for startups will evolve to embrace the changing technology and the new trends in doing financing a startup anywhere in the world. Startups and crowd financing are an emerging trend and new development in today's economy and legal industry, and a crucial vehicle in the supporting of younger entrepreneurs, for example, investors, service providers, governmental associations, and authorities around the globe. The nature of the startup business is often disruptive, with a need to grow quickly. Economic and legal regulations have to adapt to these rapid developments, in particular legal regulation, which often lags behind. Many startups are now embracing digital business opportunities like fintech, global business networks, and many social movements now globally are coming up to work with each other to provide services and goods that are often also difficult to track their financial benefits or transactions. However, while many may share the view that the legal industry is old and traditional, laws and regulations are constantly evolving as well in order to adapt to new technologies and practices. At the same time, the changing economic climate challenges the way we draft and negotiate contracts to best manage risk and streamline our ability to do business, and also bearing in mind risks like fraud, and since it's of course in the international arena, these are also part of the game. So global legal services will have to come into play. For example, the International Association of Lawyers is just to mention but a few, which is a global and multicultural organization for the legal professional that facilitates professional development, stimulates learning, networking, and promotes the rule of law. Yes, my keywords are startups, globalization, and international. Thank you so much for your audience. I think now I can be able to turn on the video because I'm...
Sure, you must switch on your webcam. I would like to request the attendees to kindly drop the reviews until the time Ms. Ninja turns on her webcam and rejoins us. Seconds.
Yes, thank you so much.
Ms. Ninja, if you could just switch on your webcam.
Oh yes, I ended my presentation. Thank you.
Okay, that's great. So, anyone, if you have got any questions you would like to address Professor Ninja or any of our other speakers or panelists for today, you may just unmute yourself and address your question. Come on, faster. Anyone, any questions? Mr. Saroj, Vassar, Ravichandran, Rajat, Vikramaditya Package. Any questions out here? That's great, Dr. Rajat. We're lucky to have you as one of our participants for today. Anyone else? Any questions out here? You simply unmute yourself and ask. Oh, fine then. I guess your speech was quite clear, Professor Ninja, along with all of our other panelists. That's good. Now, we would like to thank Robina for sharing her experiences. It has greatly enriched our discussion, Professor. Please do share your email address in the chat box. If anyone in the audience would like to get in touch with Professor Nanunja for any questions you have, please do reach out to her through her email address. We would like to express our sincere gratitude to all of the speakers for giving your valuable contributions and insights during this international conference on emerging trends in commercial laws for startups. The expertise and knowledge have greatly enriched our understanding of the subject matter. We also want to extend our heartfelt thanks to all the attendees for their active participation and engagement of the event. Your thoughtful questions and valuable perspectives have made this conference a truly interactive and engaging session. Now, we would like to invite all the attendees to participate in a small voting process. Please take a moment to type the name of your favorite guest speaker for today in the chat box. And yeah, the voting will go on in the groups as well. And just as usual, disclaimer, this voting is not for you to support a competition. It's just to increase engagement levels and interaction level among the participants. Faster. I want to see one name at least in the chat. Faster. There are 40 attendees. I can at least expect 48 groups today. More. Yeah. Okay. That's the first vote. Come on, just 1 out of 41. We need more votes, right? Okay. That's great. Just to say. Faster. Come on, faster. Yeah, that's great. 5 votes. 6, 7, 8, 9, 3, 10. Faster. At least 30 more votes popping in the chat. I'm waiting for all of you. Come on. Great. Excellent. Yeah. That's great. So as we wrap up this conference, we would like to kindly request all the attendees and speakers to take a moment, provide your valuable feedback and reviews on Google listing specification. I would also like to request you to just reshare the link and the draft again in the chat box. It would be quite valuable for all the attendees as well as our upcoming conferences where we can surely implement all your recommendations and suggestions now. So obviously your input and thoughts are highly appreciated as they will help us improve future events and upcoming conferences, continue delivering high quality events to support entrepreneurship development. Looking ahead, we are excited to announce that our next conference will be held in July from 15 to 17 next month on the topic of building trust and credibility, authentic digital branding for startups. In our next conference, we'll explore the strategy and best practices for startups to establish a strong and credible digital brand presence in today's competitive landscape. Hope to see you all there, ready to delve into another intellectually stimulating and insightful session. Please do share your review, and yeah, whoever would like to have a recording of this, all the 3 sessions of our conference 2.2, do kindly subscribe to our YouTube channel, SK Associates Center. You can just simply search for us on YouTube and subscribe to our channel. All the recordings of these sessions of this conference, along with the recordings of all our previous conferences, are available there. So yeah, I would like to request the HR team to kindly share the certificate issue link in all our WhatsApp groups so that all the attendees may fill it and obviously avail your certification. In case you do not get a certification by tomorrow end of the day, you may mail at head.hr.skandgroup@gmail.com. I would like to repeat it. Please note it down. head.hr.skandgroup@gmail.com. Yeah. Once again, thank you, and you may leave the meeting for today. We look forward to reconnecting with you at our upcoming conference next week. Till then, keep dreaming and keep moving. Have a great day, everyone. Thank you for your appreciation, Mr. Guledia. do not forget to drop a review in the for this. Thank you.
Thank you.